Can I start? You don't need to. I'm okay. Okay. Good morning, everyone. I'm going to go ahead and get started. My name is Sarah AuMiller, and I'm in a, yes?
Can we hold just a couple minutes? The other room was delayed, so we might be able to hold.
Sure, that's fine by me.
Is that all right?
Are you all getting feedback? I don't know if it's me. I'm going to stay away from that. All right. Well, I'll go ahead and get started, and we'll kind of ease into everything so that the bulk of the information will be not right this moment. So thank you all for being here. Thank you so much for having me. Again, my name is Sarah AuMiller, and I am an attorney with the law offices of Hoyt and Bryan. And we are estate planning and elder law attorneys. Those are the only practice areas that we focus on, and that's what we specialize in. I know the elder law designation sounds a little bit strange, but here in Florida, benefits planning, so planning for a family member with a developmental disability who would potentially be eligible for government benefits, falls under the elder law umbrella. So, and it's always a big fight in the Florida bar as to whether we separate it out or keep it under the elder law umbrella, but for now it's under the elder law umbrella, but understand that that's really kind of special needs planning and benefits planning. So those are practice areas that we do specialize in. So today I am going to be talking about special needs trusts. I am also going to be talking about kind of the legal aspects or the legal things that happen when an individual becomes an adult and turns 18. Now you see that I have specifically listed guardian advocacy as something that I'm going to be talking about today. I realize I do a lot of speaking to Florida-specific groups, and guardian advocacy is the process we have here in Florida that's specific to guardianship for someone with a developmental disability in Florida. Obviously, if you're from a different state, you're going to have a different process, so I am not going to get into the details of the guardian advocacy process like the slides have. What I'm going to do is just kind of talk generally about what happens when an individual becomes an adult and what you need to be thinking about in regards to your child. Okay? Sound good? All right. So, but first we're going to talk about special needs planning. So special needs planning is estate and financial planning that is for families who have an individual with special needs who might be eligible now or sometime in the future for resource-tested government benefits. So what we're really doing here is talking about how do we plan for someone who, in order to receive benefits, can't have, quote unquote, too much money. So when we have a family, we have parents who want to do estate planning, and they want to put instructions in place so that when the parents pass away, their assets transfer to their children so that their children have resources for their lifetime. That's what we're talking about, but specifically, how do we do that in such a way that those assets are there and available for an individual with a developmental disability who is also receiving resource-tested government benefits. So what is special needs planning? Special needs planning is estate and financial planning, which is designed to provide for and protect a beneficiary with special needs while preserving entitlement to needs-based public assistance programs, if any. And what I'm specifically referring to would be SSI, So that's supplemental security income. That's a program that falls under the Social Security Administration umbrella, and then Medicaid. So those are the most typical resource-tested government benefits. And I will also say, I should have said this in the beginning, this presentation is broken down kind of into 3 parts. So what my plan is I'm going to get through my slides in each individual part, and then pause to see if there are any questions related to that specific section, and then we'll move on to the next several sections. So if you have questions, I'm happy to answer them. I will also wait once we're done. I can also answer questions at the end. But I do want to try and move through the presentation because we only have 50 minutes. Okay. All right, so what are some common ways that families plan for individuals with special needs? Well, unfortunately, the most common way that we see is that families do nothing. So believe me, I get it. There's all kinds of things that you have to think about when you're raising children and have a family. Often, estate planning is one of those things that kind of gets pushed off because it is something that you don't necessarily think you need at this exact moment. So it gets put off, and then when something does happen, families don't have a plan in place. So just understand that if you don't have estate planning in place, it doesn't mean that you don't have a plan. It means that you don't have a plan that's specifically tailored for you and your family. If you end up having a disability yourself as the parent, or when you pass away, if you haven't specified what you want to have happen, we're looking to your state statutes to understand how your assets are going to be distributed, to whom they are going to be distributed, and in what manner. And this is particularly problematic when it comes to a family who has an individual with special needs in the family, because typically the state's default plan would be an outright distribution to specified beneficiaries. And that's what we're really trying to avoid when it comes to an individual who is receiving resource-tested government benefits. Because if we have somebody who is receiving, let's just say SSI, and SSI tells us, or Social Security tells us, that to be eligible for the SSI benefit, that person, the individual receiving the benefit, can't have more than $2,000 of countable assets. Well, if we have an individual who doesn't have any assets, they are eligible for SSI, but then they have a parent who passes away, and the child is what's called the intestate beneficiary, meaning the parent died without any type of planning, then that child is likely going to be an outright beneficiary, and that means assets are going to be transferring to this person who really can't have assets in their individual name and continue to be eligible for SSI. So that's really what we're trying to plan for and prevent when it comes to special needs planning. So another way family members plan for individuals with special needs is sometimes families receive what I would say is bad advice. That they go to an estate planning attorney and they say, well, I have a family member who is receiving resource-tested government benefits, and the attorney says, well, that person can't have more than $2,000 of countable assets. So what we're going to do here is leave all the assets, we're going to create a plan and leave all the assets to the individuals in the family who aren't receiving government benefits, and then they'll use that money, the siblings typically will use that money to provide for their sibling who is receiving resource-tested government benefits. So essentially disinheriting the individual who is receiving the benefits. And that's not a good plan. If you don't take anything else but this away today, please understand, if you are planning for an individual who is receiving government benefits or may receive government benefits in the future, you don't have to disinherit them. You don't have to create a plan that leaves nothing to that person and kind of leaves it up to other family members to provide care to that person. we can set up a plan and structure it so that there are assets that are there for the individual that aren't going to disrupt that person's government benefits. So another common planning strategy is gift to third parties. That's kind of what I was just talking about, which is, leaving the person who's receiving the benefits out of the plan, out of the will, out of the trust, and leaving assets to the family members, understanding that those family members have no legal obligation to use those assets to provide for the care of their sibling or whomever, whatever the relationship is. There would be a moral obligation, but no legal obligation. And life gets in the way. Bad things happen to good people. So even if we have a situation where the sibling who is inheriting the assets plans to use money to help care for their sibling receiving benefits, sometimes that sibling is going through a bankruptcy, is going through a divorce, and those assets are now exposed to kind of the life of the sibling and potentially wouldn't be protected for the individual. So outright gifts, also another way we plan for individuals with special needs. But then the best way to plan for someone who is receiving government benefits is to use a special needs trust as part of the plan. So there are very basically two types of special needs trusts. There's what's called a first-party special needs trust and a third-party special needs trust. So the first-party special needs trust is sometimes referred to as a self-settled trust, and then the third-party trust is just typically called a third-party trust. The difference between the two trusts is whose money is going into the trust, and we'll get into the details of those trusts in just a second. But what are the advantages of using a special needs trust as part of an estate plan? Well, the biggest advantage is that any assets that transfer into a properly drafted special needs trust don't count as the beneficiary's resources or assets. So basically, it's a way to kind of create a pot of money. It's basically a pot of money that's there to be used for the individual who is the beneficiary of the trust, but the assets aren't considered owned by the individual. Consequently, if someone is on SSI, that person can't have more than $2,000 of countable assets, but SSI rules tell us that any assets that are in a properly drafted special needs trust don't count as the individual's money. So consequently, in theory, you could have $5 million in a special needs trust there for the benefit of the individual, but not be disqualified from government benefits that are resource tested, saying you can't have more than $2,000 of countable assets. So that's really the biggest benefit of a special needs trust. Some ancillary benefits that the trust allows continued management for the family when typically parents are no longer available. So a trust is a legal document, right? It's a stack of papers, and it's basically instructions that are created or put in place by the person creating the trust, what we call the trust maker. So the trust maker, usually parents, are creating a trust and putting instructions in place in this legal document that control how the assets that are owned by the trust are managed. So that's really what a trust is. It's a legal document that's controlling any asset. So a bank account, an investment account, real estate, any asset that's titled to the trust is controlled by the instructions in the legal instrument, in the document. So the trust allows the family to kind of say, the parents, if I'm not here, here's who I want to be in charge of these assets. Here's how I want these assets to be used. So it's a way to kind of put instructions in place as to how assets are to be managed. The special needs trust also allows for greater independence for the individual because we're maximizing both private resources and public resources. We're allowing the individual to have these assets that were transferred to them by family members or friends or whatever the case may be, while also being eligible for the government benefits. And improper planning can lead to uncertain outcomes regarding an individual's future. So the reverse, I like to kind of say it in the reverse, which is by having a special needs trust, it really does provide some certainty to your child's future. Another benefit that I always say I'm going to add in, but I never do, I think one of the other biggest benefits to using a special needs trust is the trust really protects the assets. So it protects the assets for the individual, meaning that, if that person is if they're exploited, if they're taken advantage of, those assets are locked down and not available for exploitation. Also, to the extent that the individual, maybe is just not a good money manager, is very generous, which is typical. Any assets in the trust aren't exposed to, again, that person mismanaging or giving the money away. So that's another benefit of a trust, of a special needs trust. So again, as I mentioned, there are two types of special needs trusts. There's what's called a first-party self-settled special needs trust and a third-party special needs trust. So the difference is whose money is going into the trust. A first-party trust is funded by the individual's own money. A third-party trust is funded by family members' money, friends' money, someone other than the individual's money. So typically, I think that's what this says, it depends on whose assets is going into the trust. If the beneficiary, if the individual who's receiving government benefits has their own money, in order for that person to get eligible or continue to be eligible for benefits, we would need to create a first-party trust. Their money goes into the trust, the first-party trust. That allows them to qualify for any resource-tested government benefits, and the money is there for that person for whatever they need during their lifetime. If someone else's assets, like the parents' assets, other family members, like grandparents, friends, someone else's assets are creating and funding the trust, then we're going to be in a third-party trust situation. Now, why do we care? Why do we care about the difference between the two? A first-party trust is what's called a payback trust. So if we have a payback trust, a first-party trust, the trust requires that any money that's left over in the trust when the beneficiary passes away, that money has to go to pay back Medicaid for any benefits that have been received. So a first-party trust is great if we have a situation where someone has money, we still want them to get eligible for benefits, but we understand that whatever's left over in the trust when that person passes away doesn't go to other family members, it goes to pay back benefits paid to that individual during their lifetime. A third-party trust does not have a payback requirement. So if we have a situation where parents are wanting to provide for their children, we're of course going to create a third-party trust. We set it up so when the parents pass away, their assets transfer to the trust for the benefit of their child who's receiving government benefits. It never actually goes to the individual. Consequently, in the eyes of Social Security and Medicaid, that money, those assets are never counted as the person's money. Consequently, we're protecting and preserving those resources for the benefit of the individual during their lifetime. And then when the beneficiary passes away, then Whatever's left over doesn't have to go to pay back Medicaid. It can go to whomever the trust maker has designated as the successor beneficiaries. I see the question back there. I'm coming, I promise. So this is just, there are different types of first-party trusts. It's based on the federal statutes that allow or exempt the trusts. The most common trust that, I'm kind of running low on time, so I'm going to move through this. The most common trust that we use for somebody who is receiving resource-tested government benefits is that D4A. It's called a disability trust. So that's typically what we're using in a first-party situation. But most commonly, when I'm doing planning for families, I'm creating a third-party trust. We only create first-party trusts when we're forced into the situation due to if there's a personal injury award to the individual, that's their money. There's nothing we can do about it. If there's some type of outright inheritance or accumulated assets, those are all things that require us to create a first-party payback trust to allow the individual to continue to be eligible for benefits. Most commonly, though, we're creating third-party trusts. Again, they're typically created by the parents as part of the parents' planning or funded by grandparents or other friends or family members. There are two types of third-party trusts. There's what we refer to as a testamentary or standby third-party trust. That's a trust that's actually embedded in the parent's last will and testament or revocable living trust. So it's like it's literally part of the parent's legal plan. A standalone trust is its own separate entity that is essentially effective as soon as it's signed. Why we would do a standalone trust versus a testamentary trust is if we have multiple people other than the parents wanting to contribute to the trust. So I'm actually doing two, like this week, I just did two third-party standalone trusts. One was a case of it was parents, but they are divorced, but they're both wanting to provide for their child. They're both doing their own separate planning, but we're creating this separate standalone trust so both parents can point, they can do their own separate planning, but point to this standalone trust. And neither one's planning is contingent on this separate standalone entity. And then I have another situation or another client where we're creating it because parents want to provide for their child, then grandparents also want to provide for grandchild. Now, I will caution you, a lot of times I'll have clients say, well, yes, the grandparents do want to, provide for my child. Most typically, grandparents are setting up their estate plan, so their assets are transferring to their adult children. And then it's up to the adult children to do their own planning, and then they plan for their child. It's not always the case, but just, that's something where if you're thinking you would be creating a separate standalone third-party trust so that multiple family members can contribute, you probably want to have that conversation with whomever you think might also be contributing, because it may be that really everything's just going to flow to you, and then we can do the testamentary trust. It's really just the cost. The testamentary trust is cheaper to create than a standalone trust. All right, I think we already went through this. It's important to understand anytime we're creating a trust, you have to think about who's going to be the trustee. So typically when we have parents creating the trust, the parents can be the trustee, but then we have to think about who's going to be the trustee if the parents aren't available. Now I know there's an asterisk saying we don't recommend friends or family to serve as trustee, but that would be for a first-party trust. Friends and family can absolutely serve for a third-party trust. The rules of administration are much more lenient in a third-party trust situation because there's no payback. Where with the first-party trust, there's a lot of rules and regulations that are managed or put in place by Social Security. So you can really mess yourself up if you don't know what you're doing. administering a first-party trust. So typically, we're looking to a professional trustee for a first-party trust. But again, most of the time, when we're doing basic estate planning, we're looking to a third-party trust, not a first-party trust. Okay, that's my special needs trust portion of the workshop. So I'd be happy to answer any questions that anybody might have about special needs trusts. And then I'm going to use the rest of the time to talk about what happens when your child becomes an adult and what you need to be thinking about legally when it comes to government benefits. Questions? Yes.
We actually live in Florida.
Okay, excellent. I think, do you want them to come up to the, sorry. Hi. Hi, I'm Sarah.
Nice to meet you. So we actually do live in Florida.
Okay.
And in terms of a minor who gets Social Security, if I wanted to set something up now, is there any way to put some Social Security towards a trust, or that's not allowed?
Yes, no, it is allowed, and it's a really good question. I would recommend that you would meet with an estate planning attorney to really kind of, work out a plan. But we here in Florida, and some other states as well, have something called an ABLE account, and it's basically a statutory first-party special needs trust. So you don't have to go and pay an attorney to create the first-party trust. You can just go. It's ableunited.gov is the website, and it's actually really easy to set up an account, and then you can move. I'm not saying I necessarily recommend this. It's a whole conversation, but
Sure.
But you can create an ABLE account and move money into the account, and then that money is there for the individual. It's available for what they call disability benefits, and it doesn't count against the person when it comes to resource testing for SSI.
Okay, that's cool. Then I also have another question too.
Sure.
So for parents that are not together and are doing different custody things,
Yeah.
and, like I have sole responsibility here in Florida. So if I were to set up a trust and have a designated
Trustee?
trustee,
Yes.
yes, the other parent obviously wouldn't have access to it because
Correct.
it's just that person who would be deemed responsible.
Completely separate. Yep.
Cool. Okay.
Yep.
That's it. Thank you.
Sure.
Just wondering if you have any thoughts, strategies around how to dispense of any remainder in a testamentary trust, or create incentives for the trustees to actually spend the money, because you have to make plans for what's going to happen to any remainder, as part of setting up the testamentary trust, I believe.
So are you saying, so we're setting up the third-party testamentary trust?
I've set that up for my daughter, for example.
Excellent.
My two other daughters will be trustees.
Yeah.
But not that they need encouragement to spend money for the benefit of
Yeah.
my special needs daughter, but,
Yeah.
fast forward, maybe how do you create incentives to actually spend the money so that they're not looking for any remainder?
I understand what you're saying,
Yeah.
because typically what's happening in that situation is the trust is set up for the benefit of your daughter
Right.
during her lifetime. But if it's a third-party trust, then whatever's left over when she passes away most likely is set to go to your other daughters.
Yes.
Yes.
Or
So,
in my instance, there's consideration of providing it to an agency that's been supporting my daughter in her
so
adult
that's
years.
just what I was going to say. I mean, if you really have that concern that the remainder beneficiaries are not going to spend the money for the primary beneficiary, don't make them remainder beneficiaries. Find an organization that because you potentially are also making them primary beneficiaries, like maybe a third's going to the special needs trust,
Yes,
and then a third.
that's exactly right.
Yeah, so it's not like they wouldn't be getting their share
Correct.
initially anyway.
Correct.
So yeah, I mean, if that's a concern, I would say just don't make them remainder beneficiaries.
I just wanted to air that out so that
Yeah.
everybody else would know that.
Yeah, make you feel a little more settled. And yeah, I mean, I think it's always good to, if there's an organization that you're, really feel has supported you, then that's a nice way to kind of appreciate the organization.
And can you talk about, the difference in having, say, family as trustees and some, say, agency or otherwise that's acting on behalf of your special needs kiddo?
And it really is on a case-by-case basis. We have some families where there's an obvious individual who, the family feels comfortable nominating that person to manage the money, because that's what a trustee is. A trustee is the manager of whatever assets are controlled by the trust. There are professionals who will serve as trustees. But it's, as always, a cost-benefit analysis, because a professional professional will charge. There's going to be a fee for that person to serve as trustee, where often family members are not charging. So, it just comes down to the family dynamic and what's going to work best. And there is no one-size-fits-all answer. Yeah.
Thank you.
Sure. Did you have a question?
It's more, I guess, like an example of setting up.
Sorry. I promised you I'd get back to you.
That's okay. So I guess like a good example would be if you were going to set up the first party trust, something that would go into that, other than you said the lump sum after I raised my hand, but even like their SSI would go in there if it's too much.
Correct.
Like if you're not spending, let's say you get, I don't know, $1,000 a month, and you're not spending $1,000
Yeah.
a month, you would put it in there. Or you would spend their $1,000 a month and set up a third party instead and put your money in the third party and use their money.
Okay, so this is
monthly.
we might be getting into the weeds a little bit
Okay.
here, but I think to the extent that this applies to someone, I think it's a really important concept to understand. So if we have an individual, and she's referring to a situation or an example of when we have an individual who's receiving SSI. That person typically is going to be over the age of 18, and they're receiving this benefit to pay for food and shelter that they can't earn enough money to pay for themselves. So that's what the SSI benefit is. It's to pay for food and shelter. Well, often this individual is living with their parents. So now we have a scenario where the now adult child is living with their parents, and the parents are providing the food and shelter that they've provided for their child's entire life, which, to be fair, you're legally obligated to provide until the person is 18. What changes when a person becomes an adult is you no longer have that legal obligation to provide food and shelter. So if you are continuing to provide the food and shelter, even if you're getting the full SSI benefit, which is about $800 per month, I promise you, you are paying more than $800 per month
So basically pay yourself.
for the care of your child. So when that money comes in for your child, it is for your child. It is for their food and shelter. You're providing the food and shelter. Move the money out of the child's account into your account, because it is now your money. It is legally your money. I'm not telling you anything tricky here. Then, to the extent that, if you're lucky and don't actually need that money to cover the food and shelter that you're providing, then you could set up a separate standalone third-party trust, title the trust, set up an account, title it to the trust, and move that money, on a regular basis.
So basically, you use her money.
You're
You're
saving your money.
Save your
Yeah.
money for them.
Yeah,
Okay.
yeah.
That's
So,
yeah. But you kind of answered it. So
okay, yes. So again, I apologize if that was a little confusing, but it does kind of, I think it's important to understand. And I have so many parents who are like, I don't want to take my child's money. Please understand, legally it isn't their money if you're providing the food and shelter. Their benefit will actually be reduced if you aren't technically charging them for the food and shelter that you're providing. So anyway, okay, yes.
Thank you so much for this. We have a question from
Sure.
Stephanie Purdue online.
Okay.
She already has a special needs trust, but she hadn't been aware that there are two types, self-settled and third party. So she can obviously ask her attorney, but where else could she find out what type was set up? Is it on the paperwork in any place?
So typically, typically you would want to look to where it's talking about how the assets are being. Oh, got it. Okay. You need this. Yeah. Sorry. No. Yeah. Okay. I think. Okay. Now I know it's like a brain. What's in what hand? So if you're wanting to determine what type of trust you have, it's kind of by default. You would be looking to the distribution portion of the trust. And if it's a first-party trust, you'll see that the assets of the trust are to benefit the individual. And then when they pass away, there should be a provision that says money would go to the state agency that manages Medicaid, so like DCF here in Florida. So DCF would literally be listed as a beneficiary of the estate in a first-party trust. You're not going to see that in a third-party trust. So that's, when I'm reviewing a trust, because trusts are called weird things and people put weird wording, that's the key to determining the difference between a first and third-party trust.
Awesome, thank you.
Sure. Okay. Sure. Okay. All right, so we've really kind of gotten into this already, but it's really important from a legal perspective to understand that when your child turns 18, that really is a line in the sand when it comes to what you can and can't do for your now adult child. So from birth to 18, your child is obviously under your care. And this is where I mentioned earlier, you have the ability to make decisions regarding your child's care. You are also legally required to provide care and support for your child. So under 18, you can make healthcare decisions for your child, you can make financial decisions for your child, you can make education decisions for your child. But the minute that person turns 18, you no longer have that right. Regardless of their legal capacity, their legal ability, you don't have that right. You also have a legal obligation to provide care and support to your child to the extent that you are able to do that until they're 18. The minute they turn 18, you no longer have that legal obligation. So what that means is kind of the takeaways are twofold. The good news is if you have a child who potentially is eligible for SSI, but you've applied and you've been denied because you as the parent make too much money, the minute your child turns 18, you can apply again. And as long as the person qualifies medically, they should start receiving SSI benefits, because prior to 18, an individual is what's called deemed to their parent. So it's not only the individual's assets that Social Security is looking at, it's also the parent's assets. Once the person turns 18, the parent's assets are irrelevant. So that's a big thing. The other big thing is you can make medical care decisions for your child until they turn 18, and the minute they turn 18, you no longer have a say absent some type of guardianship, or here in Florida, we have guardian advocacy. So this has become a really, really big deal and a really hot topic and I'm not looking for any type of political discussion. But it's become an issue with COVID vaccines. That, basically if we have somebody with a developmental disability and the parents want that person or that person wants to get a COVID vaccine, a lot of times the people, the healthcare workers administering the COVID vaccine, if the person's over 18, they won't do it unless there's some form of guardianship in place. If it's the parent who's kind of, saying, we want the COVID vaccine. So it's a big deal. So just understand, and again, I I have a lot of slides that are specific to Florida. Here in Florida, we have a process called guardian advocacy. It's a special form of guardianship. So guardianship is, again, state-specific. Even here in Florida, we have all different types of guardianships, but the guardian advocacy process is the specific process that the Florida legislature put in place for families who have a family member who has been diagnosed with one of these specific developmental disabilities. So I have clients ask me all the time, well, should I do guardian advocacy? And the answer is, if you qualify for guardian advocacy in Florida, you want to do the guardian advocacy process because it is a much easier process than what I refer to as the traditional guardianship process. Traditional guardianship here in Florida is usually for someone who at one point had capacity but has now lost capacity, like an elderly person with dementia. Sometimes we have to go through guardianship in order to help that person. That requires a medical determination of incapacity. There's a medical panel that gets appointed. There's all these evaluations. I mean, it's a very involved process. With guardian advocacy, we're able to bypass that process and basically end up in the same position. The parents, once guardian advocacy is in place, parents have authority to make decisions on behalf of their child. So if we have a medical event where let's say we have somebody who's over the age of 18, let's say they have a fall, that person breaks their arm. The appropriate medical treatment that's being recommended would be that there's, some type of cast or something that's put on the person's arm to heal the break. But let's say that person says, I don't want a cast, not maybe fully understanding, the whole situation. In that example, the parents would have the ability, regardless of what this now adult child is saying, the parents would say, would be able to say, it doesn't matter whether, they want the cast or don't want the cast. We recognize that's the appropriate medical treatment. So then the doctor has legal authority to proceed with administering, what the recommended treatment. So that's really what guardian advocacy does. And every state is going to have some type of process that basically allows the delegation of an adult's rights to whomever is designated as guardian or conservator or whatever the terminology might be in your state. So these are all specific to guardian advocacy. I'm not going to go through all of this. For any of you who are interested in guardian advocacy specifically, my office, we do a workshop typically quarterly, and we do it via Zoom. So if you want more information, just go to our website and you can sign up for the workshop. But I just want you all to really understand that when your child becomes an adult, from a legal perspective, things do change, so you kind of need to be aware of what's happening. Here in Florida, we can't file for guardian advocacy until the person turns 18, because the idea is you can't take rights away that the person doesn't even have, and they don't have the rights until they become an adult. So timeline-wise, if you have a 10-year-old, don't feel like, oh my gosh, I haven't even heard about guardianship and I have to pursue guardianship. No, it's something that happens right around the age of 18. Also for Social Security benefits, don't think that you can kind of get a jump on applying for SSI. I guess you can try. Now, if your child is going to be eligible based on your financial situation, then that's a different story. But if you're a parent who has more than $2,000 of countable assets, if you apply for SSI prior to your child turning 18, they're going to be denied. If you wait until after the person is 18, your assets are no longer relevant. And I have had clients who have told me that they've called the Social Security Administration to, get an application for SSI a week before their child's 18th birthday, and inevitably the person gets into the system improperly. They get into the system as a minor, and it becomes a big mess. So this isn't really legal advice. This is just practical advice. If you're wanting to apply for SSI, I really would recommend to wait until your child turns 18, because otherwise the process just gets a lot more complicated. Okay? All right, so I think that's, again, Casey asked me about this. So if you are looking for recommendations for elder law or benefits planning attorneys, these are some of the organizations that you can look to for information. The Social Security Administration's website is actually really, really good. It's just really, really extensive. So you kind of need to know what you're looking for, but they have good information. The Special Needs Alliance is a national organization, so that would be a good resource. The National Academy of Elder Law Attorneys, that's NALA. That also is a national organization, obviously. The Academy of Florida Elder Law Attorneys, that's AFELA. Good for those of you here in Florida, but most states probably have the equivalent. And then we also have a book. It's called Special People, Special Planning. It was written by Peggy Hoyt, who is one of our managing partners, and it is available on our website. It's also available on Amazon. And this workshop was kind of based on that book, but over the years, I've kind of modified it, but it's a good resource as well. All right, so any questions? I'm happy, yes.
Two questions. The first one is, you mentioned about the trustee not being a family member and the alternative of having professionals doing
Yes.
that. Is there like any kind of foundation that manages as trustees along, and what recommendations or what considerations should they have for that?
Yes, so here in Florida, we have, they're kind of local organizations, but they are professional trustees. So most states are going to have not-for-profit organizations who serve as trustee of special needs trusts and of typically like that list of D4As, D4Bs, and D4Cs. It's just you're going to have to kind of dig in for wherever you are and get the recommendations from an elder law attorney or from other organizations that would have that type of information. So the answer is yes, but I can't give you the specific information because it's more local.
Okay, and the second question is, what is the best option for trust when we have a typical older child and a special need younger one? And because we don't want to leave any expense for the elder child, we want to leave different assets for each one of them.
Yeah. So I think what your question is what's kind of the best plan when you have a typical child and a child with special needs? Kind of how do you split it? And there isn't a legally correct answer for that. It just really comes down again to your family dynamic. Now there are financial advisors who work specifically with individuals who have developmental disabilities, and they'll do just kind of like some financial advisors can do like they can give you a projection of like when you should retire and how much money you need. They can kind of do something similar, excuse me, for what would be the lifetime expenses for your child. So that sometimes can give you kind of like a better idea.
All right, thank you.
Mm-hmm.
More question from
Sure.
the online crowd, also
Okay.
a point of clarification. How can you determine if the trust that you set up was testamentary versus standalone? Because the person with the question believes that her trust won't kick in until she passes, which
Right.
made her think testamentary, but other people are feeding into it.
So the testamentary trust is literally in either the last will and testament of the parent or in the parent's, revocable living trust. So it's literally like a section in in the parent's will or their own trust. If it's a standalone trust, that's all it is. It's just, it'll be titled whatever the name of the special needs trust is. There's nothing talking about, what happens when the parents die. I mean, it's just a separate standalone document. Thank you. Sure. Hi.
I don't know if you'd be the person to answer this
I'll try.
question. So my son is 19. Last year at 18, he got SSI. We did guardianship and all that too. So it was during COVID, which was its own beast in itself.
Yes.
To get that process was
Yeah.
extended a bit, but he got the base amount. Last
How
year,
much
it
is
was
he
like
getting?
520,
Okay.
and now
Yep.
it's like, we get
Yep.
like 580 or something,
Yep.
and it was 700, it was the max, and now it's 800.
Yeah.
So quite a few of my friends, that happened too. They just got the base amount, not the full amount, even though they asked an interview, what would you charge? Or, if somebody was renting and all of that. So other friends of mine, they went and they went back and said, well, I would charge $400
Yep.
was the amount. $400 was the amount that they would charge for rent, and they got it overturned and got the maximum. Well, I did that, and they said, oh, sorry, your mortgage is too much, and based on 3 people, because it's only the 3 of us now, my husband and my
You just
son,
have to go
it's
back.
too much.
Yeah.
So then people said, well, gosh, if you go back, they could deny you totally.
No.
And I was like, so now I'm paranoid going back, so I've just been getting the base amount, so I didn't know what your thoughts on that
So
were.
what I would do is I would add in food costs as well. So
Yeah, well, I've been tracking everything too.
you just have to get the right person.
And then I transfer, every month, the first of the month, I transfer the rent amount.
Yes.
And then I use his debit for, groceries and, all that things too. So do you suggest, you mentioned earlier, do you suggest moving the entire amount to my account, or just, because he has a debit?
Yeah.
So just move the whole
Yeah.
thing and then
But
track it that way?
you're charging him $800.
Because I was just tracking it like, I use his debit card
Yeah.
at Publix and, Walmart or whatever
Yeah.
for clothes. So you suggest putting it, the whole amount
Yep.
in there?
Yeah, because I promise you're spending more than that.
Oh, absolutely.
Right, yeah,
All right.
yeah. Okay, thanks, everybody.
Sarah, thank you very much. That was excellent. I can tell you firsthand, as your kids get older, if you can get a lawyer like Sarah, do it. You're going to really need those kind of supports in your life. Again, thank you very much. We're going to adjourn for lunch. If you go out the doors, hopefully you'll see to the right, I don't know if there'll be signage up, but the room on the other side of this wall is where lunch is being served. There are 2 buffet lines. One is for adults and the other for kids. I think it's going to be a mashup, but, everybody have fun going into the next room, getting something to eat, and we'll come back here for a 1 o'clock start. Thank you.